Timmins, James Bay.
We're proud to rise in this House tonight to talk about some fundamental issues that have to be addressed in terms of the underlying principles of the rules of law and the rights of Indigenous people in this country, where we have a government that has defied the Human Rights Tribunal, a government that has refused the order of Parliament to address the $155 million shortfall in child family services and continues to carry on that underfunding. But also, the actions that we're seeing right now from the Indigenous Affairs Minister and the Attorney General to go to Ontario Superior Court to deny basic legal rights of survivors of St. Anne's Residential School, fundamental questions about the right to the rule of law, that all these actions together show a complete disregard in terms of this government's promise to a new relationship. We have the Indigenous Affairs Minister saying that their attack on the rights of St. Anne's is not an attack on the survivors. It's simply an attempt to quote, "We are seeking clarification on the term procedural fairness." Well, of course, Mr. Speaker, that's not true. They're actually at Superior Court to overturn the right of the chief adjudicator to address serious breaches in justice. So what are we talking about? Well, let's talk about, there's two cases. There's victim C14114 and also the case of H15-19019. Now, this is a horrific story. He was raped as a child by a priest at St. Anne's Residential School and participated in the process to have his case adjudicated fairly, and his case was thrown out because the Justice Department was sitting on thousands and thousands of pages of police testimony that identified the perpetrator, the priest, and his case was thrown out because he couldn't establish where the priest was. What we know now is that the Justice Department had put together a persons of interest report on this priest that was 96 pages long, that involved numerous witness statements of other acts of child sexual assault that included 2,000 pages. So procedural fairness to the chief adjudicator was because the government suppressed this evidence, he had a right to have his hearings heard again. And yet the government is saying that they will fight that in Superior Court. Now, of course, we have to ask ourselves, why would a government in 2017 suppress evidence of a serial predator who preyed on children in St. Anne's Residential School from 1938 to 1976? Why would they have that case thrown out? Why would they be in Superior Court now saying that after being forced to turn over the documents, the police evidence, to the tribunal, they're now saying that the tribunal evidence that the police brought forward cannot be used? Why? Well, they're saying that there's significant limitations on using new information. This isn't new information. This is information that was suppressed by department lawyers from the Attorney General working on behalf of the Indigenous Affairs Minister. And this is also a breach of the fundamental reason they obtained this evidence in 2003 when they went to Ontario Superior Court to gather that evidence that identified 180 perpetrators of abuse at the time. In the affidavit by Justice Department lawyer Hania Sheikh stated that they needed access to this to defend the government, but also, quote, "it would assist all parties in corroborating and substantiating plaintiff evidence." There is something fundamentally wrong in the law system of our country, where the Justice Department will argue that Indigenous residential school survivors who suffered from having their cases falsely adjudicated under false narratives that were put forward by Justice Department lawyers who identified the perpetrators, who had the witness statements, who have been found out, and are now saying that that evidence can somehow not be used because it would be unfair to the federal government. Canadians deserve better, and the survivors of St. Anne's.
The Honourable Parliamentary Secretary to the Minister of Indigenous Services.
Mr. Speaker, I'm pleased to rise today and address the question asked by my colleague from Timmins, James Bay. I'm particularly pleased to address this as the Assembly of First Nations Special Chiefs Assembly takes place in Ottawa this week. I'd like to recognize the AFN and the National Advisory Committee on First Nations Child and Family Services Program Reform for their efforts and advocacy. Our government agrees that we must completely overhaul child and family services for First Nation communities. We need to increase proactive support for children and their families, keep more children out of care, and support them to grow up in their families and communities with a secure personal cultural identity. We know that to truly end discrimination, we must reform the current broken system and provide funding to better meet the needs of First Nation children and families. The issues are complex and the solutions are multifaceted, which is why we are working with the provinces, experts, and First Nation partners to ensure the well-being of children come first. We believe that solutions made in partnership will yield the best long-term lasting results. We have heard from First Nations that the development and implementation of the vision for change must be placed in the hands of Indigenous governments and their membership. This will enable Indigenous peoples to directly address healing and prevention needs. It will also respect that one-size-fits-all approach to child and family well-being does not work. Currently, the standards and values of children's aid societies across the country do not consistently reflect the standards and values of First Nation peoples. Some provinces are making strides to change this, but more work is required. This is why the Minister has called for an emergency meeting on Indigenous Child and Family Services to take place in 2018. This meeting will bring together the federal government, province, territories, Indigenous leaders, provincial advocates, and experts to discuss how we can work together to transform Indigenous child and family welfare so that it is child-centered, community-directed, and focused on prevention. Our priority continues to be first and foremost the well-being of First Nation children, and we are committed to working in partnership to better support First Nation children, families, and communities. Thank you, Mr. Speaker.
The honourable member for Timmins, James Bay.
Thank you, Mr. Speaker. I thank my honourable colleague. The question of protecting the rights of children is the fundamental question before us, because Edmund Matatawaban, who survived St. Anne's Residential School and has been such a powerful voice for justice, who has tried again and again and again to speak with the Indigenous Affairs Minister and the Justice Minister over the abuse of rights and the re-victimization of the survivors of St. Anne's, said something extremely powerful when we were dealing with the suicide crisis in Mushkegowuk territory. And he said that the road from St. Anne's Residential School to the suicide crisis of the young people today is a straight road. And you can follow that road through the injustice that has been suffered. And so for the young generation who are being taken from their homes in Treaty 9 territory and put into the broken foster care system, and we have 11 young deaths just recently, to a government that is an Ontario Superior Court saying that the basic right of law for survivors of St. Anne's doesn't.
Honourable Parliamentary